Alex here with part 15 of the My Docket series on child custody and visitation. As with all my previous videos, I'm going to take this opportunity to direct my viewers to part 0 if you haven't seen it yet, and that is the video with the detailed disclaimers and the underlying purpose of this series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. Please do not feel like I am currently suffering or that I am in the middle of actually battling my ex, because my case is completely and totally closed. It's over. My ex's parental rights were terminated. My case cannot be reopened. It's over and it's done. The second thing I wanted to mention is the purpose, in a nutshell, of the series is to provide my viewers with one big, gigantic example of my 8-year-long high-conflict child custody dispute from beginning to end in chronological order. Another thing I wanted to mention is I'm getting some emails from people who are following the series and they are wondering why they are missing videos. The reason why is it's not enough to just subscribe to the channel. You also have to click on the bell notification. If you don't do that, YouTube will only send you notifications by email sometimes. I'm not sure how their algorithm works, but they're not going to let you know each and every single video that is posted on the channel unless you also click on the bell notification. So with my previous videos, I typically go into my mindset first before I actually get into the documents. My mindset at this point was actually somewhat positive. I had received the order from the domestic master refusing to grant my ex the relief that she requested on the December visitation, holiday visitation that she asked for, and the domestic master cited what I cited in my response to my ex's motion, or my ex's lawyer's motion. The domestic master cited that, or agreed with me that this issue was more appropriately before the district judge in our child custody action. And so having received that order, I felt like I presented some logical objections to the court, and the court listened to me, even though I didn't have an attorney. And it gave me some hope that maybe the district judge would listen to me as well. Because up until that point, I had gotten several orders denying from the district judge and from the domestic master, and my ex was able to get an extended order of protection. So this was really the first win. It wasn't a very big win, because it's not as though my ex's request was denied entirely, but it showed me that on occasion I can present an argument and get somewhere. I mean, I can actually affect the outcome of my case even though I don't have an attorney. And so it emboldened me a little bit. I wasn't completely, excited that I would be able to get justice in this case, but I felt like here's an example that I can actually get somewhere, even though I have no attorney, even though I'm doing this on my own. And so the case management conference began to approach, and I knew that that was when the court was going to take a look at giving me more substantial visitation, and also take into consideration the fact that I wanted to spend Christmas with my son, especially given the fact that I hadn't seen him hardly at all the 8 months prior. And so these were things that I was looking forward to. I wanted to also go ahead and mention that the case management conferences, they're supposed to work a certain way. But at the time that I was litigating my case in the 2nd Judicial District Court, which is Washoe County, Nevada, the judges were kind of doing their own thing. And they were using the case management conference as a sort of second settlement conference, which, I mean, I guess I could say it's not really appropriate because they're not doing that anymore. So I'm not sure if they decided on their own volition to stop that, or if they got a scolding, I don't know, from the Supreme Court or something like that. But they don't do that anymore. They actually do use case management conferences to schedule, like, the discovery and the deadlines and the time limits and the limitations on the discovery tools. And I believe they also set, like, a trial date, stuff like that. Back then, when I was involved, when I was litigating my case, I didn't go through that. And so I didn't learn what case management conferences were supposed to actually be about until several years later. But I went to court, and it was, as I mentioned earlier, it was kind of like a sit down with the judge, and he was trying to get me to sort of agree or at least come to an agreement with my ex on certain issues. And I'm going to go into more detail as to what my experience was in the next video, because this video isn't actually going to cover the actual case management conference. It's just going to cover my ex's attorney's filing of the case management conference statement. So let's go ahead and take a look at what my ex's attorney has filed. One of the first things that I want to point out with regards to statements is that this is an area that self-represented parties often make a big mistake. Typically, when you're representing yourself, you are reacting. You're not taking proactive steps to read the rules and learn the law. You'll typically get a document and you'll think to yourself, how do I respond to this? You might pick up the phone and call, an attorney or the self-help center. You might go online and do research. But typically, when you're representing yourself, you'll get some document from an attorney and you'll think to yourself, what do I do in reaction to this? How do I respond to the court? And this does not work with statements. Statements such as the case management conference statement or the pre-trial statement, these documents are not something that is or that are filed to sort of request that the court take certain steps, so much as they are required to let the court know specific details that are outlined in the rules. So when it comes down to statements, what is supposed to be contained in the statement doesn't have to do with what kind of relief you're requesting. I mean, that's taken care of in other filings, other motions that have been filed, or the pleadings in the case. And it has nothing to do with you trying to react to something that your opponent is doing. It has everything to do with looking through the rules and determining what it is that the court needs to know at that juncture in the proceedings. So typically these will get filed at the last second, typically the day before. Well, I don't want to say the day before, because from what I've read in the court rules, it's supposed to be filed 2 weeks prior. But typically it's not filed early. It's filed 2 weeks prior, or maybe 2 weeks and a day prior to the case management conference. And so in this case, my ex's attorney filed it the day before. From what I've looked at in the court rules, that's a violation of the rules, but maybe it was just something that my ex's attorney forgot to do, or maybe the rules are changed now. I doubt it. I doubt that the judge is going to want something like this filed the day before, because there needs to be an opportunity for a party to raise objections at the case management conference with regards to what's in the case management conference statement. But in this case, my ex's attorney filed it the day before, and just right then and there, had I wanted to react to this document, I wouldn't have had time to do it because I got it the day before the hearing. And in fact, my review of the docket indicates that I never filed one. So I, representing myself, violated the rules because I never filed a case management conference statement. And I went back and I looked at the notice of case management conference, and right there in the notice, it orders both sides to file a case management conference statement. I didn't file one because I didn't know what I was doing. I was representing myself. I did notice the portion of the notice that informed me that it was necessary to file a financial disclosure. I didn't file one of those either, having received that notice, but I did file one prior to that. So I can only guess that I figured that that filing of the financial disclosure form was sufficient for what the court needed. The other document, though, the case management conference statement, I didn't file, and that can really blow up in your face. I can't remember being chewed out for it, so I don't have a recollection to sort of let you guys know about, but I can tell you that it can blow up in your face to not comply, especially with a pre-trial statement. Those are really big deals, and not filing one of those can be so fatal to your case because they're supposed to contain disclosures like witness lists and stuff like that that could cause you to not have the right to bring any witnesses to court. So I'm going to go ahead and start to scroll through this case management conference statement that she filed. And yeah, right here she says it's for December 12th, but she filed it on the 11th. So she filed it the day before. I highly doubt that the court rules back in 2008 allow this. And had I known the rules, I would have probably objected and told the court that, I didn't have time to review this. This is unfair. And honestly, to my viewers who are watching, I wasn't lax about any of this because it was a choice. I had no idea what was going on. So don't make the mistake that I did and just let something like this slide. You need to object if your opponent's attorney is not complying with the court rules. Even if the judge decides to allow it, decides to let it slide, at least at that point you've preserved that issue for appeal if it comes up later on, if it's relevant. And you never know, the judge may agree with you. The judge may say, this is really, there's some complicated things in this statement, and that person who is representing themselves has made a valid objection. You didn't follow the court rules. They were supposed to have 2 weeks to review this, and so we're going to reset the case management conference statement. And the judge might even sanction the attorney. They might punish that attorney. And that's also in the court rules. Failure to comply with the rules as to early disclosures, mandatory disclosures, and the case management conference process. The court has the authority to punish a lawyer for that. And if it's the lawyer's fault, if it's not your ex's fault, if it's specifically the fault of the lawyer, the judge can fine that lawyer or their law firm directly. So let's continue on here. Introduction. This is basic details with regards to the case. This is required in the rules. It's just to let the court know who's involved, how many children are involved, stuff like that. Support in custody, that's another thing that I noticed was in the rules. This is information that has to be provided in the statement. And I keep bringing this up because I want to make it clear to my viewers, this is not an opportunity for you to just sort of treat it like a letter, like you're trying to communicate to the court with a letter. This is something, it's an obligation that you have to convey certain information to that judge, and that certain information is outlined specifically in the court rules, at least in Nevada. So what you have to do when you provide one of these statements to the court is review those rules and identify precisely what it is you have to notify the court of. A lot of people who are representing themselves will either not file this at all, or they'll file it and they'll just rehash out all the arguments that they've brought up earlier, like in their petition or in their complaint or in their motions that they filed. Anyway, don't want to get too off track here. It's letting the court know what my ex is requesting with regards to custody and visitation. It's letting the court know. Apparently it's changing my visit, or asking the court to change my visitation schedule from 8 to 5 Tuesday and Friday to 9 to 5 Thursday and Friday. I'm not sure if that was granted. I imagine it might have been. I'm not sure that I would have cared to have him 1 hour less. I mean, I do want my son as much as possible. Maybe what I did, I can imagine what I did was just bump it from 8 to 5 to 9 to 6. But I don't remember, and rather than read ahead and read the court's order, I like to kind of go through these, I guess they call these impression videos, to give you guys my first impression as to what I'm looking at. I haven't read this ahead of time, and sometimes I'm not exactly sure what's going on, but I go through the documents and it jogs my memory a little. So this is where my ex requests that we exchange at Wendy's, and this did actually get ordered. I can recall this. We were exchanging at Wendy's, and I could have sworn it was midnight exchanges at Wendy's, but here it says 5 p.m. That changed when I got joint physical custody. So at this point, when I just have visitation rights, it looks like I was just doing the exchanges at 5 p.m. But we'll see when we get to the order in the next video. This request here for the half the insurance premiums and half the unreimbursed medical expenses, that's in the law. So, I mean, that's mandatory. There's nothing I can really do about that. And that applies to her as well. Here is the request for the Christmas visitation that my ex is asking for, and this is something that my ex asked the domestic master to grant in her motion that I went over in, I can't remember now. It was either in part, I would say, it was either in part 12 or part 13 of the My Docket series, where I go over the motion that my ex filed. But the domestic master denied this request, and so she's now asking the district judge to allow her to exercise that visitation. If I remember correctly, the district judge sided with me on that, but I might be wrong. And again, we'll check that out when we get to the next video and actually look at the court's order. She's asking for us to go to mediation, and that actually is ordered. And we do go to that first mediation. Set a hearing in the matter if mediation is unsuccessful, which it's not. It's not successful at all. And then here's a child support. It's a request for $239.50 in child support. This is a temporary request, so this will be a temporary child support order. And we can go over that in the next video too, because she doesn't get that amount. She gets less, and that's only for the short while that we are waiting for a final order from the court. Once we get a final order from the court, she ends up having to pay me child support. Affirmation, I've gone over these. Ooh, this is the first time that my ex's attorney has not attached the gigantic self-help affirmation. She's included a custom affirmation in the actual document itself. This is the way that most attorneys actually handle the affirmation in Nevada. They don't just staple a gigantic one-page self-help form to the back of their papers that they're filing. Certificate of mailing, standard. I've gone over these a bunch of times. It just lets the court know that this document was mailed to me at the address that's been provided on the date that's been detailed in the actual certificate. And I do want to mention that this is the appropriate way to attach certificates of mailing to the back of a paper pleading that's filed. I don't even know if these are, yeah, they could be attached like to an answer. And I'm trying to distinguish this from the other way, which is to file a completely separate affidavit of service or proof of service. It's better because you're filing less documents with the court. It's better to just include one of these at the very back of whatever it is that you're filing with the court that's going to be served on your opponent. It's just less paperwork for the court. It's less entries on the docket. It's much more efficient. It's cleaner. It's more professional looking too. And once I figure out how to draft my own custom papers, this is the practice that I begin to I basically copy my ex's attorney and do the exact same thing. It's just more efficient. And so that's the end of the case management conference statement. Let's move on to the next document. So this here is my ex's financial disclosure form. Now, unlike me, she has not filed one of these prior. I filed this either on the day of or very shortly thereafter the filing of the petition. My ex did not file this until December 2nd, when the court ordered her to do so. Well, the court ordered both of us, but I just assumed that the one that I filed earlier was fine. So she has finally disclosed her finances, and this is one of the things that's very important that you get consistent with the court rules a couple of weeks prior to the actual case management conference, because a lot of people try to game their finances. They really do, and it becomes one of those issues of contention, especially in a divorce, because there's a whole lot more that's being dealt with regards to finances in a divorce than there is with a child custody action involving two unmarried parties. Now, I have redacted this document. This is the first document that I've redacted. A lot of the other documents, I've just disclosed everything because it's ancient history. It's really old information. But this is my ex's document, and it contains her financial information. And even though it's really, really old, I still want to cover all my bases and redact information that is sensitive. On my right screen, I have the unredacted version of this. So you're going to see me looking back and forth between these two documents because there may be redacted information that I want to discuss with the viewers that I don't actually want to reveal. So if you see me looking to the right, it's because I'm looking at the unredacted version of the form as I continue this video. So scrolling down, you can see here, you know, it's her workplace. Everybody knows that. I mean, you could pull this stuff just from public documents anyway. Okay, so this is interesting. She's paying her attorney $250 an hour. Now, when I started the series, towards the end of every video, I would do the financials, and I guessed that her attorney was being paid $250 an hour, and now I can confirm that I was actually right in my guess of $250 an hour. This retainer that she paid for $1,500, that's really low. I am surprised that she was able to pay such a low amount. A lot of these attorneys want $2,500 or even $5,000. Some attorneys want even more than that, $7,500, $10,000. But in this case, my ex paid her attorney $1,500 retainer, and the hourly rate is $250. Scrolling down, this is the income schedule. This is something that you'll want to scrutinize very carefully in your case. Now I've redacted all of this information. I'm going to go ahead and take a look and see if anything jumps out at me as alarming. Well, the first thing that I want to mention is her grossly income was probably 3 times what I was making. Based on the number that I'm looking at here, the deductions, these numbers look normal. The income tax deduction looks a little high. She probably claimed 0 allowances. Yeah, I mean, that's a chunk of change that they're taking out of a check. So it looks like about a third. So I'm imagining that she's claiming 0 allowances and then getting a really big income tax refund. Some people would do that. Okay, I'm going to move down again. The expenses. Now, in my case, these didn't matter. There was no alimony on the table because we weren't married. It was just child support. And child support in Nevada is based on growth or gross monthly income, not on income after deductions or after expenses or anything like that. So she claims I suppose this is a reasonable amount of expenses. I actually don't even redact this because a lot of this stuff it's not private information. It's a lot on childcare that she's spending. Those are a lot of expenses. Nothing here jumps out at me. I'll take a look at those on the other sheet here. Oh no, nothing alarming, nothing seems off. I didn't really scrutinize this very carefully. I mean, when you get something the day before, you don't have the time to. This is her car. I decided not to redact that because, I mean, you could see somebody driving around in their car and kind of guesstimate how much it's worth. You don't really, it's not private. If you see somebody driving around in a Corolla, you can, do a little bit of research online and figure out how much it's worth. So paychecks. So a lot of this information is redacted. I'm going to take a look at my screen to see if anything jumps out. Well, I mean, first of all, you're going to want to compare these numbers to the numbers that are provided in the financial disclosure, because if you think the judge is going to do it, they're not. You really need to speak out if you see something off. If the math is off, if they've done something weird like with the averages, or if maybe they set themselves up to claim, oops, I dropped a 0 on accident, or I didn't count at one of the paycheck stubs. I'm sorry. And this is your opportunity to really check and make sure that that math adds up with those numbers detailed in the disclosures. There is some unredacted information on how many hours she was working, but I mean, that's not really private. You can tell how long somebody's working just by how often they're going to work. So you can tell here she's working full-time, 80 hours. Second paycheck stub, same as the other. Nothing really jumps out. And the third paycheck stub. I don't know about everyone else, but in Nevada, you're supposed to attach 3 of your most recent paycheck stubs to the back of the financial disclosure form. And there is the generic affirmation attached to the back of the disclosure. Gone over that so many times, I'm just going to move on. And another certificate of mailing, and this is just letting the court know that this specific document was mailed to me. Wait a minute. What? Oh, okay, never mind. It was mailed to me on December 2nd, so I would have got it around December 5th. Now, this makes me want to look at that other form, though, because this form was filed the day before. But it was mailed to me on the 11th? I wouldn't have even gotten this on time. This was mailed to me on the 11th. I probably didn't get it till the day of or the day after the case management conference. Wow. All right, I'm gonna move on from that. That's definitely not cool, because I probably showed up in court and didn't have any idea what my ex's disclosures were. Maybe the attorney gave me that document on the day of and said something like, we forgot to do this, or we got really busy, or we didn't get the information when we needed it, and so just in case it didn't get mailed to him, here we go, we're going to hand him the document. That is just not cool, and I wish it would have, I wish the judge would have chewed her out, because that would have jumped out to me as an issue, and I would have remembered it, and I would have been able to tell you guys in this video. But it seems to me that it got swept under the rug, because I can't remember anything. Nothing jumps out at me with regards to me not getting this statement, or maybe it wasn't even discussed in court, and the judge just assumed I got it. So anyway, I'm going to move on, but that's, yeah, to mail something the day before, the person's not going to get it on time. Moving on to the third document. This is an affidavit of service that I filed. I've gone over a few of these before. The document, I didn't even, oh, here we go. This is just me indicating to the court that I served my response to my motion, or to my ex's motion regarding my ex's motion to set visitation. Oh my God, I filed this in the wrong case. So my ex filed a motion to set holiday visitation, and that was filed in the other case, in the domestic, in the protection order action. So I remember going through that video and mentioning that it looked to me like I did not serve that document, that response to motion. Well, apparently I did serve it, and I filed the affidavit of service in the wrong case. So this is a great opportunity to let my viewers know, don't do this. If you are filing a certificate of service or a proof of service or an affidavit of service, make sure you file it in the correct action. I filed this in my child custody action, and I should have filed this in the domestic, or in the protective order action. I've gone over these a few times, and it just really lets the court know how a document was served and when it was served. So in this case, I served that response to motion personally on my ex, not my ex, sorry, on my ex's attorney. So I went to the law office and dropped it off, and I did that on November 4th. I'm going to move on to, oh wait, there's a little bit more here. Affirmation. So I've mentioned this a few times and I've skipped over it, but just to remind everyone what this is for in Nevada, it's a piece of paper that tells the clerk of the court that you have reviewed the documents to make sure there's no social security numbers in the document. So that's all it is. It's just me saying, hey, I checked this out and there's no social security in there, and you provide your signature, and the clerk doesn't usually check. Sometimes they do, but they'll usually just check to see if the affirmation is there, and they'll just take your word for it. So if I say to the clerk with this document that I've signed that there's no social security number in it, that's typically good enough for any clerk, and they'll file the document. I don't think other states use this, but I might be wrong. There may be other states who also require that a litigant affirm that a document that's filed doesn't contain a social. Next document. Another affidavit of service. Oh, okay, so this is the affidavit of service with regards to my filing the response to motion regarding mediation. And I went over that document a few videos back. It's a document that wasn't really necessary, the response to mediation, or the response to motion regarding my ex's request for mediation. But at this point, I'm just telling the court that I have served her with that, and again, it was served personally on November 4th. And I have mentioned this before as well. You don't really need to file these as a separate document. It's great if you prepare your own custom papers and pleadings, and where appropriate, you just include it towards the end, if not maybe the final, sort of statement or certificate or whatever, of whatever document it is you're filing. That way you don't have to file something separate. And also in Nevada, a certificate of service doesn't need a what do they call it? A notary seal. You don't have to have it notarized. And when you go and get these documents from a self-help form, sometimes you end up having to go and do all this extra work just because you don't even really understand that there's a whole different way to go about doing something. And in this case, I didn't know that I can prepare custom papers and pleadings. I didn't know that I could just include a certificate of service at the back of whatever document I'm filing. And I didn't know that if I had done it that way, I wouldn't have needed a notary to stamp it and sign it and charge money. And in this case, it looks like this might be the notary that worked at the Self-Help Center, which indicates to me it was free anyway. But even if it's free money-wise, you still have to take an extra step. You still have to do one more thing that you wouldn't ordinarily have to do if you figured out a little bit more as to how the law works and if you figured out how to prepare custom papers and pleadings. And you're going to see me do this very soon. I haven't figured it out yet. Not yet, not in December of 2008, but I will figure it out, and I won't be filing these separate affidavits of service every time I serve something on my ex's attorney. Going into the aftermath, I filed 2 documents, both of them affidavits. They were free, so I didn't have to incur any costs. My ex filed the financial disclosure and the case management conference statement, and those documents are also free, so she would not have incurred anything in costs. Then, with regards to attorney fees, I didn't have an attorney, so I incurred $0 in attorney fees. My ex had an attorney who we now know for sure charged $250 an hour. It's no longer a guess. To review each of the affidavits of service that I filed, she probably charged 15 minutes for each one, so that's a total of 30 minutes so far. To file the financial declaration, I imagine that my ex's attorney, because she would review it and let my ex know if there were any problems with it, or if there weren't any problems, she would still double check. So let's assume a half hour. So that's a total of an hour so far. And then she also prepared and filed the case management conference statement. Now that one I can't say she would have charged less than an hour. In fact, she might have charged more. But given the fact that it wasn't a very lengthy document and the fact that we're erring on the conservative side, we're not trying to exaggerate these numbers, let's just leave it at 1 hour. So that takes us to 2 hours in attorney fees at the rate of $250, means my ex would have paid $500 in attorney fees. So as with all my other videos, if you have any questions, feel free to post something down in the comments below. You can also download the documents. If you look down in the description, you'll see the links. And I will see you guys next time.